Yes, Mr. Kumar.
My lord, in item number 9, we had filed an earlier, we had filed an IA for bail. My learned friend wishes to file a objection to that IA. My only prayer is that your lordship will kindly fix on a particular date for listing of the matter.
Item 9, the IA. Yes, how much?
After 12th, Your Lordship.
Okay, Miss B. Buyan, additional PP, submits that she'll be filing written objection to the application under section 430 BNSS within 2 weeks.
Yes.
Within 2 weeks. On the prayer of Mr. B.D. Kowar, Senior Counsel for the appellant and applicant appellant, and Ms. B. Buyan, list the matter on
Up to
19
12th.
19,
19,
we are bless you.
1919.
Bless you.
Your Lordship, item number 10. Engage counsel for the petitioner is out of station. Kindly fix the matter next week.
You mean counsel for the appellant? Who is the counsel? R. Barwa.
Arborwa.
Okay. Who is for Mr. N. Hassan is here? No. Okay, right. Adjournment prayer has been made on behalf of Mr. R. Barwa, counsel for the appellant in Criminal Appeal 59 of 2022. The same is not objected to by the additional PP, Ms. P. Buyan. As Criminal Appeal 59 of 2022 is tagged with Criminal Appeal bracket J 48 of 2022. This is the matter after.
Next week.
This is the matter the next week.
Next week.
You inform Mr. Hassan.
Yes, we inform Mr. Hassan. In item 11, Mr. N. Hassan. This is the matter after 1 week. Let's say after 1 week. Don't after a week. Yes,
Lordship, item number 14, Your Lordship.
14, 12, 13, 14 tagged.
Tag yes, Your Lordship. I'm appearing on behalf of Mr. A. Ganguly, Your Lordship.
Lordship, I am for 13. Lordship, I am for 13.
Yeah.
I am for 12.
Any objection?
Lordship, I will do my case.
You all are all co-accused, correct?
Yes, Your Lordship.
They are all.
Both brothers. Same both brothers.
Same.
I will do my part, Lordship.
Look, the problem is we cannot complete. It has to be done together. Yes, piecemeal will be a problem. That is, you see, we have got no problem if you all do it today also. But it should be done together or tomorrow. It should be done together. Because supposing we hear you, then we have got to hear separately and then hear that because they are all from the same incident,
Yes, Your Lordship.
same case.
Lordship, then I have a special
Prayer.
prayer, Lordship.
Yes, yes.
Lordship, I want to file an IA criminal for suspension of sentence.
That is no problem. You can file.
Amicus Curiae, as Amicus Curiae, Lordship.
Yeah, you are a Micah Scura, you can file how if you want. What is there? How does it? But then when do you want this matter to be taken up?
Next week, Your Lordship. Any date.
I will file within 2 or 3 days, Lordship.
You file if you want. What do you- Right, on the for adjournment made on behalf of Mr. A. Ganguly, amicus curiae in criminal appeal J 106 of 2022. Which is not objected to by the additional PP. List the matter after a week. As criminal appeal J 106 of 2022 is tagged with criminal appeal 301 2022 and criminal appeal J 104 of 2022. All the matters are to be listed after a week.
Much obliged, Your Lordship.
Prayer.
That we leave it up to you, madam. You don't have to give permission to eat food like that or breathe. You can do it.
Match result. Madam, with regard to item number 2, we have filed an additional affidavit to us. Madam, that may kindly be called for, my lord.
This is what I took.
Item number 2, lordship.
To that matter, we have extra copies with us, my lord, we'll be submitting that. Contempt matter.
Custody.
Yes.
For whom?
No, we're together.
Petitioner,
my
my
lord.
Police.
What has happened? Have you taken the,
Cannot be,
where is she?
cannot be. Absconding, my lord.
What about the child
And
in the-
lordship, wrong submission was made before this honorable court that the child is in the hospital. He was admitted on 22/8 at 4 o'clock, after 4 o'clock, before 5. As your lordship directed to give delivery by 5 o'clock. And he was discharged, we have got records, discharge slip.
Okay.
But other day,
as
red
it
hat
was
tickets
informed-
and all were given before this honorable court. I am not aware of it, but it was given.
Anyway, so she should be arrested as and when found,
Yes,
wherever
Lord.
found.
Yes, or not? I.
And the lordship, first day, police did not do anything. They said that it's unsafe.
Opposite party does not have any objection, my lord.
Item 15,
Matrimonial appeal. Hide 1-5.
1-5. Okay. Right. On the prayer for adjournment made on behalf of Mr.
T. Kolita.
T. Kalita. Dr. T. Kalita, which is not objected to by the counsel for the respondent. This is the matter.
18 of September.
18 September,
18, 1-8.
89.
I should not.
Huh?
15.
18th.
15 to police. 15.
Item 15, they want it on 18th.
But other side, we are not there. Matrimonial appeal. Yes. Adjournment slip is, okay.
Adjournment
Yes,
slip
yes,
there.
yes.
May it please the lordship, I am praying for listing of a criminal appeal, my lord, in orders column, my lord, if possible Monday, my lord,
Okay.
deeply. But item number 4, 5 and 6 perhaps has been wrongly listed at hearing column, my lord. It must come in admission, my lord. Questions of law has to be framed.
No, well, he had to have some instruction. That's
No, Lordship, in this case, what happened, they were directed to file amendment to the appeal. They filed, but that is not taken with the record. And substitute.
That is one part, my lord.
Fresh question of law has to be framed. Earlier, Lordship, court has come to a conclusion that they have no case. So they were, that they may be allowed to file amendment petition.
amendment to the amendment
to the
appeal.
Appeal.
That was allowed, my lord.
That has been filed.
This is your amended appeal.
We have already filed, but it has not come up with the record, I've seen.
Okay, okay.
Otherwise
So,
also, my lord, it has come up on the hearing column, so.
okay, anyway, right. Mr. A.K. Sayawala, learned counsel for the appellant submits that though the amended appeal has been filed by the appellant, the same is not on the record. Accordingly, registry to verify and place the same on the record if already filed.
Already.
If filed. List the matter after,
1 week, next week, my lord.
list the matter after a week.
My lord, on 3rd, my lord.
On 3rd.
For admission, on admission column.
Okay. Okay. Third.
My lord, 2 IAs are
Three
also there, which are already disposed of.
Which one? This 2418 and 2417, they
Yeah.
disposed of.
Yes, Lord.
On the last occasion disposed. of.
The counsels for the parties also submit that IA Civil 2418 of 25 and 2417 of 2025 have already been disposed of. This is the matter on 39. Much obliged.
May I please, Lordship? Lordship, I beg to mention item number 7.
Yes.
Lordship, my senior couldn't able to appear today, so kindly adjourn the matter for the day and. next
Why,
week.
where is he in court number 1? Where is he, your senior? Which court? Which court is he in?
Court, I think.
Which court?
I think court 2.
Court 2.
Sorry.
Which court?
6.
He is in court 6. So he can't appear here. Why?
Lordship,
But he can appear in court number 6.
no, Lordship.
Huh?
Lordship, kindly adjourn the matter for the day.
Okay, right. on the prayer for adjournment made on behalf of the Appearance Council. List the matter. Where? When?
In 2 weeks.
After?
After 2 weeks.
After two. Next time tell him that code number 6 and code number 2 are very near each other. Okay.
Oblige.
So this is an appeal by the department against the order dated 20th.
Yes, so what is your
Lordship, there are,
instruction?
Lordship, Lordship, I've checked out, there is no judgment of any High Court or Supreme Court. Only CSET has passed few orders that assessment cannot be done on say 26 AS.
So, scrap
Lordship,
the law.
but Lordship, here, in the impugn order, Lordship, please to see the original, all the discussion was made. Let's make please to see page 24.
Yes,
Below Lordship, scrutiny of available documents and finding of the investigation. It
yes.
is not the case that only on the basis of Form 26 the assessment was, the final order was passed. But the finding of the tribunal is that it cannot be done on the basis of 26 as decided by the tribunal in earlier cases.
So show us. What does
Lordship,
26 say?
Lordship, please to see the scrutiny of available documents and finding of the investigation. Last, Lordship, below.
I know.
Taxability of the service provided by the noticee, consideration on scrutiny of the Form 20 AX for the period financial year 14, 15, 16, 17, 17, 18, and ITR of 15, 16, it is found that the SSC received consideration from Control of Defense Accounts, Guwahati, DS Sonitpur, and Patanjali Ayurvedic Limited during the financial year so and so. This apparent from the fact that the tax was deducted at source and the receipt of the while making the payment is mandated by the Income Tax Act 1961 by Section 194C, 18.2. Section 194C of the Income Tax Act puts an obligation on the persons responsibility for paying any sum to contractor for carrying out the work in pursuance of the contract between the contractor and the specified person to deduct a tax at source while making a payment. Thus, it is clear that the noticee was carrying out the certain works for the Control of Defense Accounts, Guwahati DS Sonitpur and Patanjali Ayurvedic Limited as per contract between noticee and above mentioned persons. Then noticee failed to submit any contract work order and any other document which could establish the exact nature and type of the contractual relationship between two parties. Nevertheless, the present evidence is sufficient to establish that the contractual relationship of the nature of service as defined under clause 44 of section 65B of the Finance Act. Further, it appears that the SSC entered SSC earned rent from Patanjali Ayurvedic Limited as apparent from TDS detected by section 194 JB of IT Act 1961. Renting of immovable property is a declared service by section 66A. Thus, becomes taxable service as per the definition of the service provided under section 65B for 44. All this discussion was made. Only not is the case that the tax ordinary order was passed on the basis of section Form 26A as well. Not even order in ordinal.
So what were the respondents providing?
He didn't provide anything else.
No, what did they do?
Lordship,
They
they
were renting out property or what?
Lordship, they are renting out the property to Ayurvedic, Patanjali Ayurvedic, and the contract with Defense of Accounts. Lordship.
Then, so according to you, since they were earning money,
Yes, Lordship, that is,
they are liable to service tax.
yes, Lordship.
So you had demanded service tax from.
Yes, divided that final order was passed. That is, Lordship, page
No, so this page 20, 3
Is
is
that,
part of
it is a so cause notice,
show cause notice. Then
Yes.
where is the final demand?
page 29. Let's see, page 41 is the scrutiny of available documents and finding of the investigation.
Page
Page
30?
41,
40.
paragraph 18.
41, paragraph 18.
18. Taxability, heading is scrutiny of the available documents and finding of the investigation.
So, okay, now when we see the period
Not
from
fit.
2014, 15,
14,
2016, 17, what about 2015, 16? What happened to that period?
Not if they didn't disclose all these things. Even they didn't appear before the authority, not filed any contract agreements. Let's see, page 44 is the summation of SEC laws. Page 44, paragraph 26.
Yeah.
The SEC, paragraph 26. The SEC in reply to a demand sumcom notice by their written state submission dated 20/2/2021, received at the office on 26/2/21, has prayed for following them 30 days to submit relevant document. The SEC by their above letter has inter alia stated as follows. One, that he has already submitted copies of Form 26A for the financial year 14/15/15 to 17/18. Audited balance sheet for the above years and copies of RTR for the above period to the superintendent officer Tezpur. However, as apparent from the notice ITR for the year 2015-16 has only been received. Therefore, he has attached copies of the audited balance sheet and RTR of the period as mentioned in the notice once again. 3. Thus, that he had executed contract only for the central and the state government and service provided by them are outside the ambit of the service tax. Since the work order related to the earlier year was not able to locate them. However, I had approached the concerned department for issuance of duplicate extra copies and he would be able to substantiate his reply with necessary documents. The said process would take some time as he would therefore pray for executing authority to kindly grant him time for another 30 days to collect the required document. However, the SEC has failed to submit any submission to the demand sumcom notice as asserted by him. Then personal hearing was given, then discussion was made. Notice the page, finding is at page 30, paragraph 30, page 45,
Paragraph 30.
page 45.
Page 45. Yes.
The issue before me is to decide whether the SEC is liable to pay service tax, including cess to the tune of rupees 2 crore 6 lakhs and odd, is to be evaded by them during the period 14/15 October, March to 17/18 April, June, or not, or whether there is any suppression or willful statement. Paragraph 31. I have gone through the written submission of the SEC dated 20th of April, February 21, received in the office on 26/2/21. Whereas they have submitted copies of income tax return for the financial year 14/15 to 17/18, along with audited balance sheet for the financial years. However, the SEC did not submit any explanation, clarification supported by documents such as copies of work order, payment vouchers, running bill, etc. to substantiate their claim that the service provided by him during the relevant year were outside the ambit of service tax. Therefore, in absence of document recorded mentioned herein, the contention of the SEC appeared to be not tenable and the allegations made in the demand sum cause notice stand confirmed. And the SEC is
Finance Act of 1994. So your service tax, you are demanding service tax
not safe,
on the basis of section 73.
not safe. Because that is the extended period of limitation is provided for. And let's say calculation is made it,
23 or 74 or 75, which one? 73.
let's say, See page 51, paragraph 19,
Page 41.
Lordship.
Yeah.
Paragraph 19, Lordship. You look. Service tax liability was calculated according to section 67, 60
768.
of the Finance Act 1994.
768.
And apparently from
Where service tax is- where service tax is chargeable. On any taxable service. No, so show us that this is a taxable service.
Lordship section 65 BB, Lordship.
65 AB,
BB,
BB.
Lordship.
65, there is no 65 BB,
It is there, Lordship.
not in the book that you have provided me. There is 65B, 65BA, 65C. You've got only one copy, you don't have another.
Lordship.
205.
Lordship, may-
There's a big gap between us.
that may be taken up on Tuesday, Lordship.
We just want to know. Where 65BB is not here.
Lordship, it is written in the notice itself, Lordship.
It is written, but it is not in the logbook that they provided.
Lordship, then I'll provide the
Which page is that form 26, Mr. Kayal?
it is income tax form where the tax is,
Page do I find that?
Lordship.
Is that here anywhere that?
Lordship, it is mentioned, no, Lordship, it is not provided. Because Lordship,
So we have to fill the form. Actually, we can. Go to the form. You don't have the form here.
Lordship, form is not there. They were submitted by help, Lordship may fix on Tuesday. And Lordship, here the finding of the tribunal is that tax cannot be levied on the basis of section 26 AS only. And on the judgment decided by tribunal itself, Lordship. And I'll check up.
What is this 26 AS?
26 AS is a form prepared by the,
26 AS is a form.
it is a form where
It's form made under which provision of law?
and it's the income tax act, Lordship, which contains that
Income tax under section 26
AS.
or AS of the income tax.
No, Lordship, it is a form 26 AS.
Form 26 AS is made under which section of the income tax act?
I'll, Lordship, today I have not come with the
Much
book.
information, Mr. Kayal, you should have had it today.
No, Lordship,
Has come up for admission.
because Lordship, my contention with your Lordship that the tribunal passed the judgment on the basis of judgment decided by itself that section.
Maybe, but
Lordship.
why can't it decide a judgment on the basis of judgments decided by itself? Why
No,
not?
no, Lordship, it can be.
The
but-
only thing is where.
In different high courts, Lordship, the appeal has been prepared by the department challenging this order for.
Huh?
This order has been challenged before the different high courts.
Maybe, but
But
then to
Lordship-
understand the issue,
I'll,
you have got to provide us the form, you have got to provide us the
Lordship, may
basis
come-
for the basis
maybe
for the
taken on-
form being made.
maybe taken on Tuesday, Lordship.
No.
I'll satisfy you. I'll produce the form of that 26 AS.
Okay, right. Mr. S.C. K.R. Learned counsel for the appearance submits that. The tribunal has dismissed the appeal,
Allow the appeal.
allowed the appeal of the respondent on the ground that the demand of service tax is not sustainable when the same has been made on the basis of Form 26 AS issued by the income tax department. Which one? Next one. Mr. S.C. Kayal submits that he will produce Form 26 AS on the next day. and also inform this court the basis on which Form 26A had been, can be made in terms of the Income Tax Act and rules. This is the matter.
On Tuesday
on
next.
Tuesday. This is also part of that. Yeah, Mr. Gogoi, the last order, you can take it from her. She will have, everything is there. Item?
8, man. So conviction in the box Act, man.
Appeal.
Yes,
Lordship, on last occasion, I was not ready for the appeal.
you are ready today. Okay, good. Where is the appeal? This,
I am appearing for Lordship criminal appeal number 171/2023, Bipin Kumar and Bira Mahato.
correct. There are how many? Two appeals.
Lordship, two appeal. There is two appeal.
Yeah, for Bipin.
Bipin and Bira, and he is
For the other one, my lord.
Yeah, for Suraj Kumar.
Yes, my
Suraj Kumar.
20 B2C.
Yes, Lordship. Conviction under 22
Ganja.
Ganja, Lordship, cannabis.
How much quantity?
It was shown as 21 kilo.
21 kilo. Oh,
Commercial
one
quantity.
extra.
Yes, Lordship. May I read the Lordship FIR?
No, you tell us straight away. What is the issue? Well, what is the grounds of challenge?
Yes,
The
Lordship.
main ground.
My
52A.
yes.
One is 52A. Is it?
My primary issue is that physical position of the contraband materials were not proved beyond all reasonable doubt.
Physical can be constructive. Okay, so your number one ground is physical possession.
Of contraband materials
Physical possession of contraband not proved.
not proved beyond all reasonable doubt. And my second point is unfair, casual, perfunctory, and doubtful investigation of police.
What?
Second point is unfair, casual,
Unfair,
perfunctory, and doubtful investigation of police.
casual and perfunctory.
Yes, Lordship.
Perfunctory investigation by police. Then third ground.
This two is my primary ground, Lordship.
Okay. So tell us
Lordship.
how was it? How was it recovered?
Yes,
The
Lordship.
material. You were in the train.
Yes.
Huh?
We were apprehended in on 13th February 2022.
13 February 20.
2022 in Deoghar, Agartala Deoghar Express.
Agartala
Deoghar Express, train number 156.
Deoghar Express.
Yes.
Train number.
Train number 15626.
Okay. Inside the compartment while it was running.
Yes,
While the train was running.
train was running, but we were apprehended in Bongaigaon station when it was come from Agartala to Deoghar. Well,
You were inside the platform.
yes, I was
You were in the platform or in the train?
train.
You were
We
inside
were
the
apprehended inside the train.
apprehended inside the train.
Yes, Lordship.
So inside the train. So whether it was in America also doesn't matter as long as it was inside the train.
Yes, Lordship.
So apprehended inside the train.
Yes. Lordship, so may I go to the FIR, Lordship, for my convenience?
Okay.
FIR is on 13 February 2022 at paper book, page number 4. FIR was lodged by one Sanjeev Chaudhary, who happens to be ASI of GRP, New Bongaigaon railway station at that point of time. With reference to the subject cited above, I have the honor to state that on 13 February 2022 at 10 a.m., an information was received by me from reliable source that some cannabis peddler are bringing a lot of cannabis in coach number B1 of Deoghar Weekly Express train bearing train number 15626, which was coming from Agartala railway station towards New Bongaigaon Junction. In this regard, I informed Sanjay Kumar Loskar, IRP Fakiragram Camp Bongaigaon. Accordingly, a written authorization was issued to me by our IRP Fakiragram by so-and-so dated 13 February 2022, who is empowered by Government of Assam by notification number so-and-so, Dispur dated 15 May 1995 under Section 14(2) of NDPS Act to carry out search and raid. When the train so-and-so arrived at New Bongaigaon Junction at around 13.38 hours, the police party headed by me with the police personnel, namely so-and-so, boarded on train and conducted search in coach number B1 of the train. During the search, 3 suspected passengers, one with blue color trolley bag and the other 2 with plastic sacks, were noticed avoiding police team and trying to escape from the search coach. But in the meantime, they were intercepted and their belongings were searched thoroughly. During search, one blue color trolley bag containing one number of packet wrapped with brown color tape suspected to be ganja was found from the possession of Sri Sanjay Kumar Ray. Lordship, Suraj Kumar Ray, so-and-so, and one purple color plastic sack containing suspected to be ganja was found from possession of Sri Bipin Kumar, so-and-so, and Sri Bira Mahato. When the train Deoghar Weekly Express bearing number so-and-so was about to depart from New Bongaigaon Junction towards its destination, the police team apprehended all the 3 persons along with recovered ganja and deboarded from the train and returned to the office of New Bongaigaon GRP at 13.40 hours. The total weight of the recovered ganja is approximately 21 kgs. I therefore request you to register a case and take necessary action against the apprehended persons and other accomplices as per law. I also handed over the recovered ganja, the above mentioned offenders and miscellaneous case diary dated 13/2/2022, copy of the authorization along with the connected papers.
Yes.
Yes, now Lordship, this is the FIR. After FIR, may I read Lordship the seizure list?
Yes.
At page 72 and 73. 72 and 73. Each seizure list was prepared by one IO Madan Chandra Kolita.
Yes.
73 seizure list is my appellants, Bipin Kumar and Bira. I, SI Madan Chandra Kolita, Bongaigaon GRPS do hereby seize the following articles from the possession of Bipin Kumar, age about so and so, and Shri Bira Mahato, age about so and so, in connection with the above reference case.
No, page 72.
Uh,
72 is from Suraj Kumar.
Yes, I am reading Lordship 73.
Okay.
73.
So 73.
73.
That is Caesar memo. Caesar list.
Seizure list.
This is from
Uh,
Bipin Kumar
Bipin Kumar and Bira Mahato.
and Birama.
Yes. So, Lordship, there is written a place of seizure, New Bongaigaon Railway Station, platform number 1. Date and time of seizure, 13 February 2022. At about 4:30 p.m.
Yes.
Now, there is 3 seizure witnesses, Rajiv Das, Dulal Chakraborty, and Uttam Sanda. And these 3 seizure witnesses happens to be prosecution witness number 1, 2, 3. These 3 seizure witnesses were also prosecution witness number 1, 2, 3. Now, Lordship, in the bottom of seizure list, may I read it? NB. It is to be mentioned that the train bearing number and name 15626 Deoghar Weekly Express train arrived at New Bongaigaon Junction on 13 February 2022, arrived at 1:38 p.m. and departed from the New Bongaigaon Junction at 1:42 p.m. Hence, unable to seize the recovered items on running train due to shortage of time, that is approximately 5 minutes. Only, all the apprehended offenders and recovered ganja has been shipped to New Bongaigaon Junction, platform number 1, to seize in presence of witnesses by
So
observing all.
What is wrong?
Lordship, now
What is wrong with this?
there is
Nothing wrong.
nothing wrong. Lordship, I am reading for my convenience, Lordship.
No, why don't you start reading for our convenience also?
Lordship, now,
See, let us go to the issue.
yes. Lordship, now,
What do you want to show us by showing this?
I want to show that, Lordship, the contraband materials was not seized in running train as per the IO.
So what?
As per the IO, due to
It was taken down because the train has to move.
Lordship, yes, Lordship, due to a shortage of time.
Correct. What is wrong? There's
But
nothing
in NDPS, there is provision. There is provision that a authorized person may stop a convenience
wrong.
for
Not a train. Supposing it depends.
yes, Lordship.
You cannot take it. You cannot take it for literally.
Lordship, may I read?
Yeah, correct. Now,
May-
now, how does what prejudice does it cause to you?
Lordship, may I read section 49 of NDPS?
Yes.
Power to stop and search conveyance.
Yes.
Any officer authorized under section 42 may, if he has reason to suspect that any animal or conveyance is or is about to be used for transport of any narcotic drug or psychotropic substance or controlled substance, in respect of which he suspects that any provision of this act has been or is being or is about to be contravened at any time, stop such animal or conveyance, or in the case of an aircraft, compel it to land and rummage and search the conveyance or part thereof, examine and search any goods on the animal or in the conveyance, If it becomes necessary to stop the animal or the convenience, he may use all lawful means for stopping it. And where such means fail, the animal or conveyance may be fired upon. So, Lordship, now my humble submission is that when there is specific provision in the NDPS that a authorized officer may stop a conveyance using the law.
They just stopped it. When it was stopped, they have and they have unloaded it. The seizure has been made in the platform. How does it matter?
That is my humble submission. As he has not used his power under section 49, and as a result, the search and seizure was not conducted
So your
per law.
case is that, so your case is that since they were detected on the train,
Yes.
the seizure list has to be made on the train. It cannot be made outside the train.
There could have been made inside the train, but it was not made.
How
Because,
does it matter? How does it matter?
Lordship, now I go to the witness of PW 1 and 2 and 3. What they say, they are also seizure witness.
Hmm.
PW 1 at page 6. Uttam Sanda. In chief.
Yes.
I am a tea vendor in New Bongaigaon railway station on 13 February 2022 at 1:45 p.m. Deoghar Special arrived at New Bongaigaon platform. GRP personnel boarded the train and started searching the coaches. During search, GRP personnel recovered one trolley bag and a sack containing suspected ganja. 3 persons were also apprehended by GRP personnel. GRP personnel seized those articles by seizure list Exhibit P1 and Exhibit P2. And my signatures were taken in those seizure lists by GRP personnel. Exhibit P1 and Exhibit P2 are my signatures. Cross. There are 7 platforms at New Bongaigaon railway station. I have a tea stall at platform number 1 below the flyover. On that day, I was busy preparing tea at my stall. I did not enter inside the train. I cannot say from where the GRP personnel recovered the trolley bag and sack containing suspected ganja. The distance between my stall and GRP office is about 150 meters. I did not go to GRP office. I was at my stall. In the railway station, employees, TT, passengers, etc. remains present. In New Bongaigaon railway station, train comes and go within about half an hour. I cannot say if license of a vendor expires, he is arrested or not. I watched the measurement of ganja from a little distance. I do not remember when my signatures were taken by GRP. I cannot say who were present at the time of measurement of ganja and who boarded the train for conducting search. It is not a fact that I adduce evidence as instructed by police to avoid future harassment. So, as per the seizure witness number 1 and TW1, he cannot say from where the GRP personnel recovered the trolley bag and sack containing suspected ganja. Now, our Lordship, I want.
So is it your case that the trolley bag and the sack does not belong to you? Is it
Yes,
your case?
Yes, Lordship. Yes. Now, Lordship, may I go to the PW2, who happens to be the seizure witness 2 at page 8. Dulal Chakraborty, in chief. I am a tea vendor and I have a tea stall at platform number 1 at New Bongaigaon railway station. On 13/2/22 at about 1:30 p.m., Deoghar Express train arrived at platform number 1. GRP staff conducted checking and apprehended 3 persons with trolley bag and plastic sack containing ganja. The accused persons were from Jharkhand, Bihar side. GRP personnel seized the suspected ganja and measured the same. The total weight of the suspected ganja was 21 kg. I put my signature on seizure list Exhibit P1 of trolley bag containing suspected ganja, and Exhibit P12 is my signature. Exhibit P2 is the seizure list of plastic sack containing suspected ganja. Exhibit P22 is my signature. The accused persons and the seized ganja were taken to GRP office. Now cross. CC cameras are installed in the platforms of New Bongaigaon railway station. The GRP office is about 50 meters away from my tea stall. The position of compartments of the train is displayed in railway platforms. In some trains, the AC compartments are in front side near engine, and in some trains, AC compartments are at back side. My tea stall is in the middle of the platform. I did not enter the coach. I was in my tea stall. As soon as the train arrived, crowd gathers in my tea stall. At the time of selling things, I become busy for delivering goods and taking money. I cannot say how and from where inside the train GRP recovered the trolley bags and plastic sacks. I saw the same only after they got down from the train. I do not know the names of GRP personnel. They were about 2-3 GRP personnel. I do not know the names of GRP personnel who measured the seized articles and who prepared the seizure list. I do not know from which accused how much suspected ganja was recovered. The stoppage time of Deoghar Express is 2 minutes. It arrives New Bongaigaon station at about 1:30 p.m. On the day of occurrence, the train arrived at 1:40 p.m. I do not know whether GRP personnel seized the ticket from the accused person. It is not a fact that coach number B1 do not fall in front of my stall. It is not a fact that GRP did not seize suspected ganja from accused person and I have not seen any recovery. It is not a fact that I deposed falsely out of fear of GRP personnel. Now, this seizure witness also stated in cross that I cannot say how and from where inside the train GRP person recovered the trolley bags and plastic sack. Now, Lordship, may I go to seizure witness 3, PW3, Rajiv Das. On oath, I have a tea stall at platform number 1 at New Bongaigaon railway station. On 13 February 2022 at about 12:45 p.m., Deoghar Express train arrived at platform number 1. GRP staff conducted checking and apprehended 3 persons with trolley bag and plastic sack containing ganja. GRP personnel seized the suspected ganja and measured the same. The total weight of the suspected ganja was about 21 kg. I put my signature on the seizure list Exhibit P1 of trolley bag containing suspected ganja and Exhibit P13 is my signature. Exhibit P2 is the seizure list of plastic sack containing suspected ganja. Exhibit P23 is my signature. Cross. Today I have not seen the trolley bag and plastic sack in the court. I was busy in my tea stall. I do not know from where and from whom GRP personnel recovered the suspected ganja. I have seen that the GRP personnel were measuring the suspecting ganja. I have put my signature as told by GRP personnel. I do not know who prepared the seizure list. I do not know what was there inside the seized bags. I do not know how many GRP personnel were present at the time of measuring the seized articles. When I put my signature, GRP, IC and staff constable homeguard were present. I became witness in this case as asked by GRP. Now, Lordship, in these 3 PWs, my humble submission is these 3 seizure witness unequivocally stated that they have not seen from where and from whom and how that suspected materials were seized, although they put their signature in seizure list. This was my first point. Lordship, now my second point is, in FIR, the complainant has stated that he was accompanied by 6 police personnel during the search inside the train. But none of that 6 police personnel were produced as witness during the trial. And what is the legal consequence of that fact, Lordship? Section
No, what is the second point?
second point is the complainant in his FIR stated that he was accompanied by 6 police personnel during the search inside the train.
Yeah.
FIR.
6. Where does it say 6?
6 police personnel. Their name were also stated in the middle part of the FIR, Lordship. Arrived at Bongaigaon Junction at around 1:38 hours. The police party headed by me with the police personnel, namely Head Constable Tuneshwar Roy, UBC Dharani Talukdar, Sopon Kumar Roy, UBC Nitul Deka, Pinkumoni Roy, Homeguard Bijoy Das of GRP Investigation Center. So, this complainant was accompanied by 6 police personnel during search inside the train. But at the time of trial, Lordship, none of these police personnel were examined as witness to prove the fact of physical possession of contraband materials. Now, what is that legal consequence? My humble submission is that Section 114 of Evidence Act 1882, it says that
Section?
Section 114G, 114G of Evidence Act 1882, corresponding to 119G of BSA, Bharatiya Sakshya Adhiniyam. Hundred 14G of Evidence Act. Court may I read, Lordship? Court may presume existence of certain facts. G. The court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. Now, illustration part, there is G. That evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. So, my humble submission is that when the complainant was accompanied by 6 police personnel during search inside the train, he ought to have produced their
Made them prosecution witnesses.
yes, during trial, so that the physical possession of cannabis can be proved beyond all reasonable doubt. But none of that personnel were examined. Now, Lordship, now may I go to the evidence of complainant PW4, who happened to be the in charge of New Bongaigaon railway station at that point of time, Sanjeev Chaudhary.
Page?
Page PW4 is at page 13. Page 13. May I read the Lordship? Sanjeev Chaudhary, in chief. On 13 February 2022, I was posted as in charge GRP New Bongaigaon. On that day at about 10 a.m., we received secret information that ganja is carried in Deoghar Weekly Express coach number B1. After receiving the information, I entered the information by GD entry number 171 dated 13 February 22. Exhibit P3 is the extract copy of GD entry number 171 dated 13 February 2022. Exhibit P3 is my signature. I inform about the matter to OC Bongaigaon GRPS and IRP Fakiragram camp at Bongaigaon. I was authorized to conduct search. Exhibit P4 is the authorization letter which was sent to me through messenger. Exhibit P4 is the signature of Sanjoy Kumar Laskar IRP Fakiragram, which I know. Deogar Weekly Express arrived at New Bongaigaon station at 13:38 hours. I, along with my staff, boarded the train and conducted search in coach number B1. While search, I found 3 persons. 2 among them were holding purple color plastic sack and 1 person was holding a blue color trolley bag, and they were trying to go to another.
How long will you take?
Yes, Lordship.
How long will you take?
ठीक हो गया?
How long will it take? किमान नहीं लगेगा?
Lordship, I will get next 5 to 7 minutes. Purple color tape. Lordship, I am reading the next para. On search, we found suspected ganja in the purple color plastic sack and blue color trolley bag, and accordingly, the 3 persons were taken out of the train. I informed the matter to OC Bongaigaon GRPS. He said that he will come and seize the articles. We took the 3 persons along with the recovered articles to platform number 1 in front of GRPS office. The OC Bongaigaon GRPS Madan Kolita reached there, seized and measured the articles in presence of witnesses. I was also present at the time. Lordship, I now directly go to the cross part of informant. Cross. The FIR was registered at 2:15 p.m. on 13 February 2022. The GD entry number 171 dated 13/2/2022 regarding secret information that drugs being carried at Agartala Deogar Express was made at 10 a.m. I did not make any GD entry after being authorized for search. Authorization letter has no memo number. I showed the authorization letter to the accused person before search. But I did not take signature of any witness. I did not provide any notice or did not put any question
What do you
to the
want to show? What do you want to show? What is your
Lordship, yes, Lordship.
what is
I want,
your point?
Yes.
Set point on this issue.
In cross part, I want to show Lordship, page 17.
What? What?
Uh,
Don't say patient. What is the what do you want to show? He was fat, he was thin, he was tall. What?
Yes. Lordship, in cross,
Hmm.
the informant stated that 1 copy of train ticket in the name of Suraj Kumar Roy is seen in coach number B1, seat number 19,
Hmm.
upper berth. Another copy of train ticket seems to be in the name of Bipin Kumar Bira Mahato, coach number S2, seat number 8 and 6. Now, my point is that the complainant in the FIR alleged that all the 3 persons were arrested in coach number B1. But here he stated that there is train tickets of Bipin and Bira of coach number S2, which is a sleeper coach. So, how I am found in coach B1?
You are in S2.
S2, seat number 8 and 6.
Huh? Huh? So you are from coach S2.
S2.
He is from coach.
B1. It is a AC coach.
Your name is?
Suraj Kumar है मैडम.
Okay, so what you're trying to say is that since your coaches were different,
Yes, Lordship.
seizures that are made
Yes.
are from different coaches
Yes, Lordship.
would require would show that this could not have been a commercial quantity.
Yes, Lordship.
That's what you're trying to say.
And the train was stopped only for 2 minutes.
So you all had no clue about each other. You all did not know.
Yes,
You
Lordship.
all don't know each other. Is it?
Yes,
Or you all know each other?
yes. Lordship.
Yes, what? Yes, you're saying everything, yes. Huh?
We don't know each other.
Yes, Lordship. That is, we have stated in our 313
So
statement.
you all don't know each other.
Yes, Lordship. In 313 examination, we have stated that we do not know who is Suraj Roy. We are traveling separately in coach S2.
And which the suitcase belongs to which coach? S2.
Who, Lordship?
The suitcase is for which coach?
Suitcase belongs to Suraj.
Suitcase belongs to Suraj.
Suraj.
And for you, the polythene.
They allege that we have that package, some package.
Okay.
Package. And Lordship, now
Then. Okay, so that blue color trolley bag belongs to Suraj,
Suraj,
and that purple color plastic bag,
plastic
plastic sack
sack.
belongs to you.
Yes,
So since only 10 point something was recovered
yes,
from
Lordship.
one,
Yes,
so you should have been charged under section 20B2B.
for intermediate.
Correct, 20B2B.
20 B to B.
No.
Yes, Lordship. So, Lordship, my second. Huh? না এইটো মুকেশ নহয় লক্ষিপে মোক সাজেশন দি আছে Lordship, now my second point is that education সাজেশন দি
They've not been made.
Lordship, now my
Now I will tell you one thing.
yes, Lordship.
It is 2 o'clock or 1 o'clock.
1 o'clock. Yes, Lordship. Exactly, Lordship.
So we will do it after that.
Lordship, at 2 o'clock I will take.
After meeting? Oh, I have got, that is at 1:15.
At 2 o'clock I
At
Lordship.
2 o'clock, we will do the other things first. At contempt matter, 2 judgments is there, that will pass, that will take just half a minute. And then that contempt matter, then we will come.
Yes, Lordship. Yeah, I have to show 2-3 judgments.
You said 5 to 7 minutes, we are already
No.
finished.
Lordship, I will take 5 minutes more, Lordship. Oblige.
Appeal is allowed, divorce is granted, liberty is also given in case of permanent. Appeal is dismissed.
Oh.
So, Lordship, I will summarize in 2-3 minutes, Lordship. So my humble submission is that before shifting the burden on accused under section 35 and 54 of NDPS Act, the conscious and physical possession of contraband must be proved beyond all reasonable doubt.
So yeah, basically cases that the foundational facts have not
Lordship.
been.
Exactly. So, Lordship, on that point, Lordship, I want to rely on 2 small paragraphs of Noor Aga's case. Noor Aga's case, it is a copy and video. 2008-16 SCC 417. 2008-16 SCC 417.
Para?
Para 58 and 59. Small para, Lordship. May I read? 58,
My God.
58. Para. Section
My God. How many judgments are you relying upon?
Lordship, I have relied upon only one, but my colleague might have relied upon few more judgments.
Who is giving this?
He's relying on one of the cases that I'm also relying on. Noor Aga is there, Lordship, on
Page.
page 170. The same paragraphs I'm relying on, he's also relying on the same.
He has made his own paper book.
Okay.
58. Section 35 and 54 of the Act no doubt raise presumption with regard to the
Yes. Read.
presumption with regard to the culpable mental state on the part of the accused, as also place the burden of proof in this behalf on the accused. But a bare perusal of the said provision would clearly show that presumption would operate in the trial of the accused only in the event the circumstances contained therein are fully satisfied. An initial burden exists upon the prosecution, and only when it is stands satisfied would the legal burden shift. Even then, the standard of proof required for the accused to prove his innocence is not as high as that of the prosecution. Whereas the standard of proof required to prove the guilt of the accused on the prosecution is beyond all reasonable doubt, but it is preponderance of probability on the accused. If the prosecution fails to prove the foundational facts so as to attract the rigors of Section 35 of the Act, the excess rears, which is possession of the contraband by the accused, cannot be said to have been established. 59. With a view to bring within its purview the requirements of Section 54 of the Act, element of possession of the contraband was essential so as to shift the burden on the accused. The provisions being exceptions to the general rule, the generality thereof would continue to be operative, namely the element of possession will have to be proved beyond reasonable doubt. Now, Lordship, my last point is that there is a contradiction between PW4, who is the complainant, and the IO regarding the seizure.
Contradiction between PW4.
4 and the IO. IO
is what?
IO is PW6. 6. PW6. Regarding seizure of the contraband. Lordship, kindly turn to the page 17 of paper book and 25.
Page 17
Page 17, 17
of the paper book.
of paper book and page 25. Page 17, it is a part of the cross-examination of PW4 complainant.
Yes.
In middle part, Lordship,
Yes.
page 17, middle part, seizure list was prepared by Madan Kolita at 4:30 p.m. after measurement. I did not do any measurement. The weight of suspected drugs mentioned in the Azahar and the actual measure was same. I did not inform my higher authority. It is not a fact that no authority letter was given to me. This is the part of PW4. Now, Lordship, 25. Page 25. Cross-examination of IO. What he says in middle part, Lordship, page 25. He says, I did not physically seize the suspected cannabis from the possession of the accused persons. I did not physically seize suspected cannabis from the possession of accused person. Whereas PW says that seizure list was prepared by IO. Modern.
PW4 is the informant.
Yes, Lordship. And he happens to be the ASI of Bongaigaon railway station at that point of time.
No, so how? What is the, where is the contradiction?
Contradiction is that PW4 is saying that Caesar list was prepared by Madan Kalita. And
PW, Madan Kalita.
Madan Kalita is PW6, IO. And Madan Kalita PW6 saying that I did not physically seize the suspected cannabis from the possession of the accused person. So my last submission is that the physical and conscious possession was not proved beyond all reasonable doubt from me.
I did not physically see. Naturally, he did not physically see what he constructively sees it. I did not physically seize. What do you mean?
Teaser memo was prepared by PW6.
Caesar memo was prepared by PW6.
In his cross
Ah.
stating that he will not.
In cross, he stated that I did not physically seize.
Let us see what he said in the examination in chief.
Of PW6.
Yes.
It is in page 22. Chief, on 14 to 22, I was posted as second officer and was in charge of OC at Bongaigaon GRPS. On 13 to 22, at 2:15 p.m., I received the Azahar and took up the case for investigation. The case was registered as Bongaigaon GRPS case number so-and-so under section 20B 2C NDPS Act. Exhibit P5 is the FIR. Exhibit P52 is my signature. I recorded the statement of the complainant at Bongaigaon GRPS. I went to New Bongaigaon GRPS Investigation Center along with the complainant. The suspected ganja was measured and found to be weighing 21 kg. I recorded the statement of witnesses. I visited the place of occurrence at New Bongaigaon railway station, platform number 1 in Deoghar Weekly Express train number so-and-so. But this statement is also false.
Huh?
This statement is also false.
What, which one?
At the bottom of page 22. The IO has stated that I visited the place of occurrence at New Bongaigaon railway station, platform number 1 in Deoghar Weekly Express train number so-and-so, post number B1, along with in charge GRPS. Because the train left at 1:40 p.m. from the station, and he got the FIR registered at 2:15 p.m. Already train left, and the IO has stated that he visited the place of occurrence. It is a false statement on the part of the IO. He cannot
How is it false?
because Lordship, what IO has stated, he stated that on 13 to 22 at 2:15 p.m. I received the Azahar.
This
I received the Azahar at 2:15 p.m.
correct.
But the train left the station at 1:40 p.m.
No, he went to the place where the Caesar memo was made. That is where the Caesar was done. Caesar was not done in the train. Caesar memo was made in the railway platform.
Railway platform, yes, Lordship.
Also,
But the PW1,
you cannot.
PW1, 2, 3 all stated that we have not seen from where, how.
That is a different issue.
Yes, Lordship.
But according, you see, yeah, you have got to see where is your query to him that the place of occurrence with regard to the Caesar list was on the train but not on the platform. It was on the platform that the Caesar list was made.
And in cross, he has stated that I did not physically see the suspected.
So I think just some discrepancy. Yeah. Don't go into those small issues which are neither here nor there. Yeah. That doesn't help your case. You keep your keep your submissions to the main issue. When you digress into small issues, which doesn't really, which are gray areas, it doesn't really help your case. You were doing fine, but you're now digressing. Anyway, what else?
So, Lordship, this is my humble submission that the physical position and conscious position was not proved beyond all reasonable doubt, and I relied upon Noor Aga's case.
Page 14. Where? On search. On the purple cover,
Case number 40.
on search, you find the purple cover. Uh-huh. Only problem is that
Like,
May I please, Your Lordship? My lord, my learned senior argued that the failure of the prosecution to establish the conscious possession of the contraband material from the accused beyond all reasonable doubts. I totally concur with the submissions so made by my learned senior. And in addition to that, Lordship, I would like to place a few judgments. Lordship, the first judgment will be,
why do you
Lordship,
want to give us so many judgments?
Lordship, I'll be,
16
I've given
judgments
a compilation of judgments. Yes.
on the same issue.
I've given a compilation. My lord, I'll be stressing on 4 grounds. One ground has already been argued by my learned senior. The other ground,
What is the foreground? One ground is?
one ground is the failure of the prosecution to establish conscious possession of the contraband from the appellants.
Number 2?
The prosecution's failure to prove the secured chain of custody of the alleged contraband from the recovery of from the time of recovery from the train till the production before the magistrate. This is in violation of section
Failure process to what? To failure
from
Huh?
the recovery till the production before the magistrate. This is, my lord, in violation of section 2, clause 2.1 and 3.2 of the standing orders dated 89, 1/89. Clause section 2, clause 2.1 and clause 3.2, 3.3, 3.4, 3.5 and 3.6 of the standing orders dated 1/89.
Do they have any statutory force?
Yes, my lord. Noor Aga has specifically said that the officers need to comply with them. My third ground, my lords, will be that as has been held by a single judge of this honorable court in Manirudzaman, that the magistrate also needs to prepare a sample. So, while drawing samples, the magistrate also needs to prepare a list certifying the samples that have been drawn along with certain details.
No, it doesn't have to be the magistrate. The enforcement agency's list is enough.
My lord, but 52A(c), 52A(2)(c), my lord, it's a twin requirement. So that was got into
It is the same thing. Why make it two?
because, my lord, to ascertain the safe custody of the
Supposing you bring it to me
my lord,
and I find that the list is okay.
my lord.
If I give my signature to that, it won't it satisfy
But my
the
lord, what of
requirement?
that?
Huh?
My lord will certify that I have the samples is drawn from in my presence, And thereafter, my lord, what will happen till it reaches the FSL? That is what I want to impress upon my lord. So that is my third ground. And my fourth ground will be, my lord, non-compliance of section 41, subclause 2 of the NDPS. That is the foundation basis.
41 is with regard to
Authorization.
authorized
My lord,
officer.
my lord.
Then,
That is my fourth ground. Because, my lord, so in this case, my lord, what has happened is that, my lord, the seizure, the officer who has done the seizure, the PW6, he was not authorized. He was only the authority was given to the PW4, who did the search. Search and seizure ought to have been done by the same officer,
when you let us see,
my lord. So, my lord, I'll start with the first ground.
give us the NDPS Act. This is the one, no? Yes.
My lord, with regard to my first ground, my lords may kindly have a look at section 51 of the NDPS Act,
51.
my lords.
Yes.
Provisions of the code of CRPC to apply to warrant arrests, searches, and seizures. The provision of the code of criminal procedure shall apply insofar as they are not inconsistent with the provisions of this act to all warrants issued and arrests, searches, and seizures made under this act. Thereafter, lordship may kindly have section 100 subclause 5 of the CRPC. So, lordship, it says that search and seizure will have to be made in accordance with the provisions of CRPC.
Two witnesses.
Two witnesses, my lord. 100 subclause 5. Very lordship, 100 subclause 5.
Yes.
The search shall be made in their presence, and the list of all things seized in the course of such search and of the places in which they are respectively found shall be prepared by such officer or other persons and signed by such witnesses. But no person witnessing a search under this section shall be required to attend the court as a witness of the search unless specifically summoned by it. Now, my lords, PW 1, 2, and 3, who are supposed to be the seizure witnesses, they are only seizure witnesses. They are not search witnesses. Now, with regards to this, my lord, the case law that I'll be referring to, because in the clause they specifically stated that they did not see the persons from whom the search was, the contraband was recovered from.
That chain is missing.
My lord, my lord, my lord. So, my lord, the first case I'll be referring to.
That is what it is. I am having single bench. Alternate matter will have to be used. Huh? And series matter. I don't know, they're putting so much. We'll continue on some other day. You
My
see,
lord,
you see,
For my lord's convenience.
you see, the thing is that you have made your point so lengthy.
My lord, the point is the grounds are the same. It's just that I'm trying to establish those grounds with legal sanctity.
You see, now because it'll take the whole day, and I've got a lot of.
My lord's convenience. My lord convenience.
You'll have to be concise.
My
Very
lord, my
concise.
grounds are limited. It's just that I'm trying to.
When
my
you
lord-
bring out this, it doesn't show that it's limited. Right. And this is a matter again on when. Second is
11th. What? Are you key? My lords, can it be next week? Otherwise, next Thursday. Because my lord has already heard the matter.
you know. Even my brother won't be there.
11, my lord, also, okay, the same problem might happen.
Huh?
11th also, my lord, the same problem might happen because my lords have heard the matter. Otherwise, my lords may keep the matters for third matter. Because my learned senior has already argued the matter for quite some time.
After 12, then what?
It becomes a problem because you see, if we put it partnered,
My lord,
sometimes my brother will have to go maybe to outlying benches also.
my lord, my lord. My lord's convenience, my lord, because my learned senior has already argued quite a bit. So, whatever my lords decide.
Give a date.
Very well, my lord.
Yes.
Instruction, madam. Lordship, I will place the peruse it, madam.
What is happening?
My lord, because my lord, now special, my lord, that committee has to be formed, my lord, for, because already, my lord, that lapsed. So for further, my lord, administrative approval, my lord, constitution of this committee is, my lord, required. So this is my instruction.
You see, what is to be done was that the PWD commissioner was to
Lordship,
conduct the technical evaluation.
lordship,
So
lordship.
has it been done?
That,
You
my
cannot
lord,
jump from one thing to the other as you like.
yes, my lord. Today, lordship, this is instruction dated, my lord, today, 28th. So, my lord, this is my latest instruction, my lord.
No, but then there is a direction passed by this court.
Between, yes,
Then-
my lord, in the month of June, my lord.
Then
That lordship, last occasion, lordship, that this communication dated, my lord, 9th of July has been placed before your lordship, my lord, because in that case, lordship,
I think, you see, now I'm DB, I'll release this, let it be placed before the concerned bench for. Mr. Pathak, what to do?
My lord, I understand, my lord, there was a inspection required to be done.
They have not done it, now they have given us some other letter from the home department.
for
That I'm not aware of.
evaluation, my lord, we have already sent. Last occasion, probably that was placed before your lordship. No. Okay, my lord. This is another instruction dated 19/7 was also there, my lord. By that, my lord, that evaluation requested for, my lord, to take up the matter with Managing Director APHC Limited, seek necessary assistance for support to ensure that the report is furnished to the department, my lord, regarding re-evaluation.
No, you see, as per the meeting minutes
My lord.
that had been made earlier, the special commissioner secretary PWD was to conduct the technical evaluation
Lordship.
and the examination of the entire issue as per the minute
My notes.
11 June.
Lordship.
Now, why is that not done?
That-
Now you are jumping to some other issue.
Send to my lordship. Lordship will take up that that 3 pages, my lord, just now, my lord, that
Yes.
lordship will take up the second page, my lord, third. That was my lord sent for, my lord, to the chief engineer building PWD Shanmari. Third page your lordship will find. On 19/7/25, we wrote to that PWD department, my lord.
Come to number 4. Number 4 point. The third page.
My notes, my lord.
Yes, the minute.
My lord, my lord.
Come to the 4th point.
Lordship.
Special commissioner.
Commissioner and secretary.
Then
to be requested to conduct technical evaluation. And as per that, my lord, we have requested on 19/7, my lord. That is yes, my lord.
No, this is of June.
This is of June, my lord. And as per, after that, my lord, we got
Why hasn't the special commissioner done it?
July, we wrote to them, my lord. This was of June, my lord, minutes of June. And the
Madam, you wrote to them,
lordship,
but this court has passed an order in June.
lordship. Yes, my lord.
Then
My lord, as per my instruction, my lord, now that special
Pathak, what to
Me
do?
too.
Now,
Lord,
I'm now.
This bound to take some time because even if the commissioner starts this inquiry, there are multiple number of buildings. So he will definitely take some time. I think a month's time or 2 months' time further would at least be required to complete this
So we
exercise.
release this matter from Pathak. Or what?
She may keep a date after vacation, maybe. Till such date something would come up.
Now, you see, if I can't decide the issue,
My lord.
why am I keeping it as Pathak?
Definitely, definitely.
We
Because
are-
the next day also they might come with the same
They-
instruction that
they-
it's
they
yet to
come
be
with some
completed. But then since the building is already complete, it should not take much time.
Correct, but they are not doing it.
Now, my lord, committee is to be, my lord, because already, my lord, it is for addition and work. So for approval, my lord, we need to form that, my lord.
I don't
as
think,
the-
I don't think you're going to do it prior to election. The manner in which you are doing it is only to ensure that till
Election,
delayed till the model code of conduct comes into.
so that no fund goes out from the government.
Huh?
So that the funds of the government is intact till elections.
No, so that it can be used somewhere.
My lord. Because this was vital infrastructure. These are the detention centers, my lord, where all these foreigners are kept. So we had to complete it at that their instruction anyhow. Before this NRC process was completed, my lord. So on great urgency basis, these buildings were completed. Now, if additional expenditure, if they say that now we cannot pay, you have taken benefit from us, my lord, at our cost, these buildings are standing as of now. And the housing board admits that, yes, this is the additional expenditure. Only thing is now the formality of, my lord, approving it.
This is because the manner in which they are doing, writing this, doing this should be done, this should be done. They are changing, you see, today they are saying special secretary or commissioner. Tomorrow, now these letters are being written by the home secretary, home department. So it is just delaying the matter. That's very clear.
Lordship may, my lord, direct to complete within, my lord, lordship may be pleased to keep it pending and my lord, within my lord, lordship may be pleased to order in between, my lord, giving time bound, my lord, if the lordship pleases. So that they will also, my lord, speed up the things, my lord.
The problem is if we dispose of the matter, they'll have to file a contempt.
No, my lord, I'm praying to, let it be pending, my lord. In the meantime, my lord, to complete the process, my lord.
Nothing happens unless contempt is filed. What to do, Mr. Pathak? The problem is I don't want to keep this pending
My
unless I
lord, I
decide.
understand. But then that exercise, since they say that it is necessary, let them do it, my lord. We have no objection to, my lord, doing it. That should be done expeditiously. From June, my lord, almost 3 months is going to elapse now.
Correct. No,
Let
not,
them have another month, my lord, after vacation, my lord, if the date is fixed. By that date, if the report is placed, my lord.
okay, right. Third, Mr. V. Pathak, legal counsel for the petitioner, and Ms. Udas, learned counsel for the response. This court had directed. No, this court had directed the matter to be listed today. No, not today.
It was on 7/8/25, and then Lordship was not sitting on that.
7/8/2025. To enable the special commissioner and secretary, PWD bracket B and NH bracket close, to conduct the technical evaluation, comprehensive examination, etc. As per the minutes of the meeting held in the conference room of the additional chief secretary, Home and Political Department on 11/6/2025. In connection with the construction works related to the transit camp at Matia in Golpara district. Wherein the following decisions were taken. The last order, you take it down, huh? Again, 1, 2, 3, 4. Okay, it is there. Okay. Today, yes, sir. Ms. Yudas has submitted letter dated
What's her date?
19/7/2025. This is the one.
But the-
19/7/2025. No, submitted, wait.
This is also, my lord, today I submitted and the,
I submitted a letter dated 19/7/2025. Issued by the Joint Secretary to the Government of Assam, Home and Political Department.
it's,
Okay, the letter number ECF number 467512/845 dated 19/7/2025. Huh? Issued by the Joint Secretary to Government of Assam, Home and Political Department. Disposed. And letter number ECF number 467512/990 dated 28/8/2025, issued by both same, huh? Same issued. First up. The letter dated 19/7/2025 and letter dated 28/8/2025 are made a part of the record and marked as an X and Y respectively. First up, the contents of the above two letters are as follows. You take these letters, you take it from here, huh? Here to here. Here to here. Okay. The respondents are directed to ensure that the process is expedited in terms of the above letters. List the matter on when
After application, my lord.
last
You-
week of October, my lord.
you did.
Deeply advised.
The matter is released from Pathak.
My lord, obliged.
Please.
There's no.
Lordship recalls this matter. This is that JV matter.
Has it signed?
Yes.
We have signed, my lord.
Signed.
We have signed.
They have signed excepting for one page, which is the most important page. Now they are cherry picking. I mean,
Wait,
pages.
show me.
yes, yes.
That is, my lord.
My friend tried. Even I have tried. But
That is the authorization of operating the bank account, my lord. My lord,
Yes,
that can be
yes.
signed, and my lord, all the three may be allowed to operate the bank account. All the
No, that is an issue between you all, not an issue to be decided by us. That is not an issue. The issue only was with regard to opening of a bank account.
But my lord, we have signed all the pages. Otherwise, we have signed everything.
Huh?
We have signed everything otherwise.
You have not signed this page.
But that is the only page, my lord.
When you sign it,
That is before the bank, my lord, because that is where that is how we operate the bank account. So all the three may be allowed to operate the bank account, my lord.
I don't know. That depends upon the. That is not an issue to be decided by this court
My lord,
to operate the bank account.
my lord, that way, my lord, we'll come back to square one. My lord.
they're going in circles. That's the point. We are going in circles.
Who is
Today
to
said-
operate the bank account?
I'm sorry.
Who is to operate the bank account?
It's me. That's Dromos, as well as any one of the parties,
So then let him be one of
Altis
them.
and KTC.
Let
No,
him be one of them.
it can't be him exclusively.
No,
because-
three of you all will operate.
Pass on, my lord. We shall all be protected, my lord. We shall all be
Three-
protected.
No. Three.
Why?
The problem here is, Lordship, that if one is not available at that point, the other will be available. So it's not that, I mean, one party will sign exclusively along with me. And if he is not available at that point of time, because and that will also be against, we have seen the conduct of the party, sir. And also what we'll see, it will be against the terms of the EPC contract. What will have that. We can't change the constitution of the JV. Please see 2.1.11. 2.1.11 says that we can't change the constitution. We can't exclude a party and say that no, this particular party will not sign. I will sign only exclusively. All three will sign. Whoever is available will sign at that point of time.
So all three will sign.
All three will sign. All three will sign the form. But he is saying that no, I will only sign exclusively
No.
for taking out the money.
No.
That's what he's saying.
No, that's not what he said.
All the three.
You see, there is no point in having a joint account and he not being able to operate it. What is the purpose? All three will operate it.
No, actually, the lead member will operate. Actually, but he will be with me. He or Altis.
Let us see the agreement that you have made.
Yes.
No, where is it here in your writ petition?
Writ petition has been disposed of. IA.
Okay, let us.
IA.
Where is the
Agreement concern. This is the agreement which I have filed. Lordship will see at page 19 first. It discloses the shares of the parties. And then Lordship has the EPC contract, page 24. This I showed on the last occasion, 1.5.2. This is very important because it says that the lead member will be responsible and the payments will be released solely to him, and the railways are not concerned with the inter-se allocation of the payments. That was the position earlier. Now there's a JV. Now since there's a JV, the lead member will remain the lead member, and KTC as well as Altis will be other signatories.
Well, that is an agreement where Altis is only taking 2% without doing any work. That is their internal between Altis and Dromos.
That's not the concern because
that
Altis is
they are a
23%.
sleeping partner. They have only 2%. They only
No, where is
They have
Just a minute. Where is the agreement with regard to the opening of the joint account?
Lordship, there was no such agreement to open a joint account. It was passed by my lords that they will be,
the council?
sorry.
You cannot change, you cannot change your stand
Yes.
every time you come to the port.
Yes.
It is not a fish market. That, this fish is fresh today, it is smelly the next day, fresh again the next day.
That's right. But Lordship will find that the
No,
order was.
you see, you've got to be fair to the court
No, I am being asked.
in mind.
No, Lordship will kindly see. That's what I'm saying.
Let me see, where is the
Order.
agreement?
There was no such agreement to open a JV account.
I think there was.
No, that's why they came to the court. JV account, I'm saying.
Just a minute, let us see. Don't just shout without knowing what you're talking about.
Yes. My lords, if I may assist the court. There is a document which I filed. This is called Decision of the Joint Meeting. There it was, an agreement was made that a JV should be formed. Here, this is at page 25 of my IA. And all the parties have signed it.
Page 25 is the agreement.
My lord,
25.
my lord, my lord, this should make it very clear, my lord. This is the letter of the railways, but well, they have stated, the railways have stated that as per the clause 3.38, there has to be a joint account, joint venture account, and money shall be deposited only into that account. That is by the railways, my lord. It is on 13th of August, my lord, this letter.
Yeah, you're waiting for.
Chief Executive letter, make it the piece of.
Let it go for arbitration.
As my lord said,
You're agreeable that it should be decided by an arbitrator.
Arbitrator. Yes, there is a. 21. The payment should come till the point, till the time,
That will be decided by the arbitrator.
because since the
Otherwise, I will decide.
We can move on to section 9, my lord, before the district court, if any urgency, if any interim order they need.
Lordship may decide, because I have instructed to say that. Lordship may decide. And also Lordship will kindly record my submission, Lordship. I have to say this on instruction. My client is willing to give a declaration to say that if any amount comes into my account, I will disburse it as per the bills raised by them, KTC, as well as Altus.
Altics is anyway getting only 2% of the whole amount of 140 crores, my lord. They are entitled to only 2% of the amount. That is they are sleeping partner, Altis. And they have no registered offices in India. They are in Ukraine, my lord.
No, they have, that's the thing.
They are from Ukraine.
They have an office in
They're
Bombay.
here today, gone tomorrow.
No.
You're right. Heard Mr. G. Kabir, learned counsel for the applicant MS Dromos Engineers and Contractors, bracket OPC Private Limited. And Mr. R. Sharma, learned senior counsel for the respondent number
1.
No, respond number.
In the IA, we are the smallest.
respondent number 1. Comma MS Agemba Transmission and Construction. No one appears for the other respondents today. This application has been filed praying for modification / clarification of the order dated 30/05/2025. Passed in WPC 2974 of 2025. Comma. To the extent that till a joint venture account is opened, comma, the railway authorities should be directed to make payment of the EPC contract bill in the account of the lead member of the joint venture, that is the applicant. Next. The facts of the case in brief is that a joint venture comprising of the applicant, comma, the respondent number 1, and And this number 3 has not put their name.
Number 3 has put the Altis.
And Altis Holding Corporation. Altis Corporation had been formed for doing the contract work pertaining to the engineering, procurement and construction relating to what?
The construction of.
Relating to railway line,
Electrical railway line.
electrical railway line
My lord.
between
Jiribam
Jiribam and Imphal.
and None.
Jiribam
And None.
and None.
Hmm.
Jiribam and None, N-O-N-E, huh? Under the NF railway. Oh, sir. In terms of the joint venture agreement made between the three parties, clause 1.5.2, 1.5.2. Come on. It had been stated that it had been stated as follows, page 24, take it down. This is the thing, 24,
Yes.
lead member,
Yes,
next.
Lord. 24 1.5.
Accordingly, all payments regarding the EPC contract had been submitted in the account of the lead member. That is the applicant. Full stop. However, a joint meeting of all the stakeholders of the joint venture company, joint venture, correct?
Yes.
And anybody else, and the railways.
Yes. I'm
And the
sorry to
railways are
interrupt.
there also.
Yes.
My lord.
And
I'm
the
sorry to
railways.
interrupt, Lordship. Lordship said all payments have not been made by the railways.
But any payments were made outside to other accounts, only to your account.
Yes.
That's what I said. All payments were made to your account, not to any other account. So what have I said? And not to any other account. Was held on 9/5/2025, wherein it was decided that a JV account would be opened and till the same was open, payments could be made in the lead member's account. The decision taken in the meeting dated 9/5/2025, wherein all the three JV members and the railways participated, is as follows. Page 25, 1 to 6, okay? Next paragraph. The respondent number 1 thereafter approached this court by way of WPC 2974 of 2025 with a prayer for a direction to be issued to the authorities not to make any further payment in the individual bank account of the applicant and to deposit the payments of the EPC contract only in the joint venture account that was to be opened. Pusta. On 30/05/2025, WPC 2974 of 2025 was disposed of with a direction that any payments to be made by the railway authorities on the EPC contract would henceforth have to be deposited in the joint venture account to be opened by the joint venture, comprising the applicant, the respondent number 1, and Altis Holding Corporation. Pusta. In the order dated 30/5/2025, disposing of WPC 2974 of 2025. The no objection letter dated 25/5/2025 issued by Altis Holding Corporation for setting up a joint venture account for deposit of payments for the EPC contract had also been submitted. Next paragraph. As stated earlier, the present application has been submitted by the applicant for a modification/clarification of the order dated 30/05/2025, passed in WPC 2974 of 2025, to the extent that till a joint venture account was opened, the railway authorities should be directed to make payment of the EPC contract bills in the account of the applicant. Pusta. Next paragraph. During the proceedings of the present IAC 1963/2025, the applicant had taken a stand that the respondent number 1 has not shown any inclination to open the joint venture account, as they have not signed the application form for opening the joint venture account, though the applicant and Altis Holding Corporation had signed the application form. Today, the application form which was to be submitted for opening a JV account in Where? In which bank?
State Bank of India.
State Bank,
Stay in the State Bank of India. Where? Which account? Which
Vidhan Nagar,
Huh?
Vidhan Nagar branch,
Huh?
Vidhan Nagar branch,
Vidhan Nagar branch. Guwahati,
Calcutta.
Calcutta. Whatever I said.
No problem.
Has been produced. A perusal of the same shows that the respondent number 1 has not signed the said application form in one place. On a query made to the counsel for the respondent number 1, as to why he has not signed the application form, the counsel for the respondent number 1 submits that there has been no agreement with regard to submits that unless and until the joint venture account is operated by all the 3 account members, the opening of a joint venture account without the respondent number 1 being allowed to operate the same along with others would nullify the necessity of having a joint venture account. Correct? Next part. Next para. Thus, the issue that has been raised by the joint venture members is not with regard to whether a joint venture account should be opened or not. It is an admitted fact that it is an admitted stand taken by all the parties that a joint venture account should be opened by the joint venture members. The dispute is centered around the members who can operate the joint venture. The applicant is desirous of operating the joint venture account in the absence of the applicant, respondent number 1. And the same is not acceptable to the respondent number.
I'm so sorry, Lordship. I mean, my submission is not that, Lordship. My submission is that they are saying that is KTC will exclusively sign along with me.
No,
So I have an objection to that.
No, I am saying all 3.
All the 3.
So if all the 3 signs, I have no difficulty. But they are saying that no, exclusively they will, all the 3 will have to sign the form.
No.
So that's all right.
But going to operation.
But the operation I'm saying, the operation part, who will withdraw the money? For withdrawing the money, I need signatures of any one of the partners.
No, all the 3.
Any one of the partners,
We have
whoever is
taken-
just a moment, sir. Whoever is available at that point of time.
Available? What do you mean available?
The expression used is either or survivor.
Huh?
Banking term, either or survivor.
That is
The expression used in the banking.
Basically, you want a joint venture account
Yes,
operable only by you.
Absolutely not, Lordship. Absolutely not.
Then
That's
what?
not my case.
Now, what is your case?
Joint venture by all three members,
Ah.
but the account will be operated by
Operated by you only.
any. Yes, I have to be with the Lordship. I have to be
No,
there
no,
because
Mr. Counsel, let us not try to talk in riddles. Don't try to insult my intelligence,
absolutely.
your intelligence.
I
The
don't have-
issue is whether you want him to operate along with you and Altus.
Yes,
Enough.
I want him.
You want him to operate. So you three will operate. Enough. End of the matter.
But if all three cannot be together all the time. All three
That is
will
a
not be
different.
available. So how do we withdraw the money?
No, we will make sure that you are. You have to be all three together. Otherwise, how will you decide? That is the problem. You see, the problem is you are going to have problem with money. Sometimes, okay, the thing is that he also will have some leverage over you, which
That's
you
not-
don't want.
Yes.
And you will want to have leverage over him also.
Not that.
Actually, basically what you are trying to say is that I am the most righteous man on, you are the most righteous company on earth,
Absolutely.
but he is not very righteous,
No.
so we cannot rely upon him. But you have to rely upon me. That's what you're saying. You are holier than thou, and he is less than the devil.
That's not my submission, Lordship.
Huh? Okay, more than the devil.
No, I'm.
Where
That's
is
not
it?
my submission. That's not my submission, Lordship. My submission is that I'm willing to work with them. We have been working with them since the beginning. But so far as the operation of the account is concerned,
That is where that is
because while Lordship, see, even after your Lordship passed the order, I mean, I'm told this that their henchmen went to their go down to the warehouse in Imphal somewhere, and they told the workmen to stop work. I mean, I'm only looking at how they're operating their
Nanda.
conduct. I'm going by the conduct, Lordship.
And I understand your apprehension.
Yes.
The problem is, I do not know whether you're Superman or you're that the devil in that Superman comics, Dr. Luther.
I'm not Dr. Luther.
So that is what in his book, he might be Superman.
Could be.
Then who am I to decide that? How do I know?
So Lordship will go by
By what
APC.
I see is fair. You see, otherwise, what is the purpose of having a joint venture account?
Quite right, Lordship. I see the point, but then
But then you tell me, you give me a solution. You give me a solution that is fair, and I'll do it. You show me a solution.
just give me one moment to consult. I have instructed submit Lordship that we can take our portion of the money and they can raise their bills independently with the railways and take their portion of the money. We have no difficulty with that. Because we are 74% together with all this and they are just 26. So they can take their share. I have no difficulty, but they have to complete the work. On the ground today, it's only 20% complete.
That is the problem. No, why did you make that agreement? And why you
That's
see,
the
you are all admitting. You see, it is not your case that you don't want a joint venture account.
Absolutely.
Your IA is also to the effect that we are okay with the joint venture account. We just want a clarification as to who should operate. Now, if it's a joint venture, it's a joint venture. If it's a joint account, it's a joint account. Supposing I have a joint account with my wife, bank account with my wife, and only I operate.
That's
If it's a joint venture, it should be operable by both.
In this case, all the three.
No, I don't know, because you might be the devil also in disguise.
But
You see, the only problem is that they have agreed to everything. You might be the
No, my lord,
spinning the wheel.
ultimately we come to the operation part, my lord. If
But that aspect, was something you should have looked at earlier. Now you want me to decide whether a joint venture account should be operated only by one person. So in Naam ka vaste, it's all for everyone. But in reality, it's controlled by one person.
I'm the 51% share.
Agreed. So how
So
do
this- So
how does this court decide
my
that
humble
issue?
suggestion, if it falls, I mean, if it commends your lordship, that they can raise their bill independently to the railways will clear their bill. We will raise, I mean, we together with Altus will raise the, I mean.
But
our
it's
bill.
a joint venture.
Yes, for the work, but for raising the bill, this might be a more,
So that's why y'all don't want to go for arbitration. I wanted y'all to go for arbitration. Y'all can raise everything there.
my lord knows that
Beyond
if we go to arbitration, the matter will be stuck and the work will be, I mean, there'll be no work on the ground.
no, I understand.
Yes. We want the work to
you
be-
probably you have a case.
Yes,
Probably you are the angel here.
I'm not saying.
No. I'm saying, assuming that you're the angel here, and he is the devil in disguise. But the fact remains is that I have got to decide on the matter on the basis of what is in front of me, not on on the basis of something that is not known to me. There's something in black and white in front of me. I can only decide the issue on the basis of that. You might be completely right that they are actually crooks. But then how am I going to decide that issue? And whether I can say in this case, when you wanted a clarification of an order, whether I can say that no, he should make his bills only to the limit of his share. Now, I do not know when you do a certain work, what is the limit of his share? Vis-a-vis the entire work that has been done. We do not
No,
know.
26%.
No, maybe. But how much? How much have you paid? How much you have not paid? That's the issue of accounts. You'll have to go into that. The problem is that you have agreed to a joint venture account.
No, I am willing to go by it. As I said to your lordship, I'm willing to go by it. I'm willing that all three, I mean, I was always willing, even today, all three will sign. But so far as operation is concerned, who will withdraw the money and who will sign at that point of time?
All three. So he's going to have a handle over you also. What to do?
My lord,
If
will
you
decide.
just think, give me if you can show me a way out, more than willing to, if it's reasonable, provided it's reasonable. He's happy because he's sitting there, everything already done.
No, my lord, because we also, our hands are also tied because we also not getting.
I do not know, but you're probably
single money.
spoke in the wheel demanding
You know, my lord,
your share.
I'm a very old contractor, my lord. I've got other projects also in the railways running. I've got 14 projects. I'm doing 14 projects.
Manipur.
Manipur, rest of Manipur, Lamding.
We have seen the projects done by them.
No, my lord.
We have seen the projects done, then maintenance costs,
My lord,
and then everything has it
my lord, we are only one of the parties.
overgrown brush and forest and
My
everything.
lord, we are only one of the parties, but Upper Assam and all, we have completed very successfully. We're still doing the work. So, my lord, we are very serious businessmen, my lord.
That is the thing. We don't know. This court doesn't know.
And it would be,
Okay, I'm deciding anyway. I have to go by what I see.
Very good.
You can go in appeal, whatever, both of you.
Very.
What have I said? To stop. No, not that. What have I said? Read the entire thing. Now, the applicant is desirous of operating the JV account individually.
No, sir.
Then with
No.
who? With
all three.
respondent number one and Altis Holding Corporation.
Yes.
Good stuff. Next, that's the Mr. R. Sharma is also agreeable to the same.
However, Lordship,
Okay,
here's the catch, Lordship.
okay.
When I go to withdraw the money, I need a signature of any one of the partners, Altus or KTC. So now they want exclusively, they will sign along with me. My signature is required, but they will sign exclusively. Altus will not sign.
No, they'll also
No, no.
sign.
Sign off.
All also
No,
sign.
Altus will not sign. Wait, just a moment, sir. Altus will not sign when Altus is available. I am saying that if Altus is present,
We'll
will not sign.
we'll make a condition here
yes,
that they should always be available.
My lord. I'm agreeable.
Okay, right. Instead of that, just that last sentence you just cut. Whatever I said. Mr. R. Sharma was also agreeable, that part. Ah. No, Mr. R. Sharma cut that. Full stop. He submits that. At the time of signing the check for withdrawal of the money, the applicant should be allowed to withdraw the money on the basis of the signature of the applicant and any one of the two remaining JV members who are present. Full stop. Next para. Mr. R. Sharma, learned counsel for the respondent number 1, on the other hand, submits that the respondent number 1 would always be ready and present to sign the signature, to give his signature for withdrawal of money as and when the applicant wants to withdraw money from the JV account.
Withdrawal and disbursal, that.
Whatever, withdraw, disbursal is a different thing. He however submit that the check for withdrawal of money should be signed by all the JV account members, that is the applicant, the respondent number 1, and Altus Holding Corporation. Next para. On considering the submissions made by the counsel for the parties and keeping in view the fact that it is an admitted fact that all the parties, all the members of the JV want a JV account, this court directs, this court is of the view that at the time of withdrawal of money, all the members of the JV should sign the check. In this regard, the respondent number 1 shall ensure that they are always present and ready to sign the check for withdrawal of money. I know it will not serve the purpose, but this is what I want. This is what the requirement. What have I said? In as much as the very purpose of opening a JV account and operating the same would be lost if all the members of the JV are not allowed to operate the same jointly. The I is accordingly disposed of.
so I would like.
All right.
Joint venture has to be signed. That page has to be signed. That page.
Yes, you sign it.
My person is outside.
Bring him here.
My lord, they tried to enter, my lord, they could not because of.
Call him. We're sitting here. You ask your junior to go and bring.
Insanity hall.
No, now you have got your order. Now you'll sit down and say, wait, I'm having my tea.
No, my lord.
I'll sign it tomorrow.
No, mine will not do that.
Huh?
He will not do that because we also want money, they also want money.
I have not.
We have to pay our suppliers, my lord. We have to pay our suppliers. Otherwise, there'll be litigation upon us from other quarters also if we do not pay them the money, the suppliers.
I have accordingly disposed of. Huh? You have to sign it here.
He'll come here.
Let him sign it in. Don't give it to them.
All right.
And if you do not sign, I'll pass the order separately.
He'll be here in 5 minutes. Obliged.
Put this up. Okay.
Look, in this matter, my lord, we have paid for a simple modification, my lord.
in case of authorized officer, because nowadays, authorized officer.
Have you paid the amount?
We have paid 25 lakhs to yesterday, my lord.
Okay, yesterday you paid 25 lakhs paid. Okay, so we'll correct that. Mr. G.N. Sayawala, learned senior counsel for the applicant, submits that the order dated 18/7/2025 passed in WPC number 3238 of 2025 should be modified so as to substitute the reference made to the chairman of the board of trustees with
Authorized officer.
authorized officer.
Authorized.
Full stop. He also submits that the applicant has paid rupees 25 lakhs yesterday, which is in consonance with the order dated 18/7/2025, passed in WPC 3238 of 2025. Full stop. Mr. R. Sharma, learned counsel for the respondents number 2 and 4.
2 to 4.
2 to 4.
Yes.
Submits that he has got no objection to the application made by the applicant. Accordingly, wherever it is mentioned in the order dated 18/7/2025, passed in 3238/2025 as inverted commas chairman of the board of trustees, inverted commas closed, the same should be read as the authorized officer. The applications accordingly disposed.
Lordship, respondent 2 and 3.
2 and 3.
Yes.
Not 2 to 4. 2 and 3. Payment made or not?
Yes, man. We've already made the payment. They've received it also. I have a.
Okay, now what is to be done? Now it seems he has got a case.
Rightly passed.
Huh?
Lower court has passed rightly.
Correctly? No, it's not correct. But you have got your money.
We have got him out.
You have got your money till July.
June
Till
30th.
till June.
I think it's more than enough now. I think, so I think that order that we had passed
Yes, ma'am.
earlier, that can be. I think it can be decided now.
Yes, madam. That is
That's 5/6/25.
5-6. Yes, madam. That already decides all the points. I have also subsequently submitted the judgment, my lord, which covers my point. I think I've already submitted as 2024 SSC Online MP 9245. That covers all the recent Supreme Court judgments also, my lord.
2000? No, you have not given me that.
2024, my lord. SSC Online MP 9245. my lord. On the last occasion, it was given to your lordships. If I need, I'll give another copy, my lord. This is a very latest judgment where everything has.
No, it's not been.
It's not, my lords, I'll just give it to your lordship just now.
Mr. Sharma. Hey, he's the one.
They're just undertaking.
Okay.
They're making an.
Yes.
Somehow I just have one copy, my lord. This is marked. I'm extremely sorry. I don't know why. I thought I had handed over on the last occasion. My apologies. This is marked.
Which one?
Abstract.
Which one do you want? Which portion? That non-supply of
Yes.
that
And that
is there already in that.
this has been reiterated here, my lord. All the judgments have been referred, and it is made very clear that now he has to come up not only has to show it, but also in pleadings it has to be mentioned. that yes, he has been affected because of this non-supply. That has not been there.
Prejudice has been caused. to
Yes,
him.
prejudice has been caused. Yes, my lord.
And that is what.
Yes.
But that is there in that what, Kamakar, Karnak,
Yes.
or
Kamakar, which is the larger bench decision. Yes, first decision, my lord.
So I think, I think
Judgment of the Firestone tile, I've already given lordship. 1973 judgment, 1973 judgment, one Supreme Court decision.
you have given.
813, I've already.
8-1.
813.
Acha, wait, I think I've got this Ajit Narayan.
Yes, my lord.
Oh, yes. Can give this back, I think. Huh? Yes. Give this back to him.
Thank you.
So I think, which judgment are you saying? 1970?
73, one SEC, 813.
I have got it here.
Paragraph 36, I'm reading.
Para 36.
36.
What does it say?
We will first consider cases where an employer has held a proper and valid domestic inquiry before the passing the order of punishment. Previously, the tribunal has no power to interfere with this finding misconduct recorded in the domestic inquiry unless one or other infirmities pointed out by this court in Indian Iron versus existence. The conduct of disciplinary proceeding and the punishment to be imposed were all considered to be managerial function, with which the tribunal had no power to interfere unless the finding was purpose or punishment was so harsh as to lead to interference of the victimization or.
What we are trying to say
Hmm.
is that the merits of the proceedings can be gone into by the tribunal.
Yes.
Correct. That is not disputed. You can go into that. I mean, the tribunal can, we cannot.
And all the witnesses will express
Ah.
them.
Wait, let me see. Yes, where is Mr. Kabir's? Yes, just see this. Say to them. If they are happy, then it's end of the matter. Okay, take it. I don't know when you all are going to meet up again in arbitration. I think you will meet soon enough, I think. Yes, so what do you want to say? Tribunal has, okay, he's got the power. So what's wrong? Now they're
And all
in the
all
tribunal's
witnesses
order.
have again been cross-examined, duly cross-examined before the tribunal.
What?
Those who were examined before the domestic inquiry, they have again been examined before the tribunal.
So,
But and they failed to prove their case in the tribunal itself. And the tribunal rightly passed the order in favor of the workman.
but you have been lucky now. You have been, you see, you have been given your money. We
This is our impact.
we waited for you to get your money. Now I think it's more than enough. Be happy with it. So according to you,
Yes, ma'am.
the first ground was that they are challenging the award on the ground that the advocate an
Was-
advocate could not be an inquiry officer.
Correct.
Second ground was that the management witnesses were not properly examined
Yes.
or were not. Where does it say that? Where is that? Where does the award?
No, that is his
That is
claim.
our
ma'am.
ground.
That is his ground.
That is our ground. also.
Okay.
His
No, no, but what was the finding of the labor court
Yes.
on that?
Ma'am, page 104.
104.
Yes, ma'am.
Yes.
The three issues have been decided.
Yes.
The first paragraph is in regards to the independent inquiry conducted by the advocate. Second is the notice of
No,
inquiry.
104 says
Yes, my lord.
Ah.
From the cross-examination of management witness, it appears that the inquiry officer so-and-so was the advocate of the management of different legal matters for the management, and as such, he cannot be an independent inquiry officer as regards to the inquiry of employee under the management. MW1 in his cross-examination admitted the fact that there is no document to show that notice dated 1/11/2011 was sent to the workmen. He also admitted there is no endorsement of such workmen have received the notice.
so this is with regard to the inquiry report.
Inquiry report being sent. Subsequently, from the scrutiny of this evidence on record, it appears that there is no document to come to the conclusion that the workman has received the inquiry report. The requirement of law is that after the conclusion of the inquiry report, the domestic inquiry notice, along with a copy of the report, shall be sent to the delinquent. However, in the present case, management has failed to do so. Apart from the inquiry officer was also not unbiased. In circumstances, the inquiry conducted by the inquiry officer was not proper. As regards to the charges of demands, bribe, and repairing of the machinery of Kellyden, as well as the supply of goods of the management, has not examined the person from whom the bribe was demanded. MW2 in his cross-examination admitted the fact that he has not seen the incident personally in regards to the alleged incident of fact of Kuldeep Singh, so-and-so. MW5 in his cross-examination stated that he has not say why written in his evidence on affidavit. This is his finding on the three witnesses. As regard
The first ground is on the
on the
On the-
inquiry officer,
and the inquiry officer being an advocate.
advocate. Second ground is the notice, which is not received by
Notice
the
that was not received. Third ground is on the ground that
or the ground that the three witnesses
Ah.
that we had in fact brought into a record saying that there was a charges of bribery. My lord, remember there were three charges. First was absence of duty, which went in his favor. Second was bribery, and third was shouting at the management officer who was in his office. Those two charges have been found guilty. In terms of that, I had produced three witnesses. The three witnesses to show that he has taken money from various other people while for doing his work. So those two witnesses was examined before the domestic inquiry. In this claim, my lord, they are saying that the inquiry officers, the two witnesses have said that we were not personally present, but we have heard that. But it is not that he was not called. He was there before the inquiry before the Labour Commission. So the cross-examination said that I had not seen him taking the money, but there are in the domestic inquiry, he says that the money has been taken. So these are the three witnesses which are brought by us to say that he has taken money in different places. That is at my lord the inquiry.
the Labour Court held with regard to that.
This is the finding, my lord. Page 104.
Ah.
As regards to charges of demand of bribery, of repairing the machines of Kellyden so-and-so, supply of goods, the management has not examined the person from whom the bribe was demanded.
Huh.
Now, that guy is not under my control. I can only bring my person to say that, yes, he has taken the bribe. That is the complaint that has been given to me. I cannot produce the guy for who he has taken the bribe. That is not with me. Number two, MW2 in his crossing admitted the fact that he has not seen the incident personally as alleged to the incident of so-and-so. So I have not seen the incident. Somebody says that he's not seen the incident. And number three, the MW5 in his cross-examination stated that he cannot say what was written in the evidence of affidavit. That is the affidavit that was given. I'll tell you also then 5.
So this does not go entirely in your favor.
No, my lord. The three evidences that were produced by us in regards to bribery were three people who were in the local market
Wow.
who came and told us that this gentleman has been taking money as bribery for stuff that is collected and given into my company, that is Kellyden. So these are allegations that has come to us and that has to be decided. So we brought the three people who came in. Before the Labour Court, they are saying that these people I could not identify who the person from the bribery has taken. No, that guy has already been examined before by the
No, no, sir, they were not examined before the.
this is what it says, my lord.
Domestic inquiry is officer also, before them also. It's totally.
I just tell you, my lord.
No charges will put against you.
My lord, to be kind enough to come to page 47, my lord. This is the inquiry report.
No, wait a minute. Let us see the charge. Where is that?
Yes, my lord. That is at page 44, 5/9/2011.
Page 44.
Yes, my lord. What your lordships are inquiring is charge number 2.
Charge number 2.
Yeah, first is absence of duty, my lord. And
Yes.
charge number 2 is bribery and soliciting. Being yourself a fitter, you have approached number 1, so-and-so tractor farm and machinery from Jaklabanda, Shankar Motors, Jaklabanda, Binod Kumar, and solicited bribe for repairing to the machinery Caledon as well as supplies by good. Your act has offended the standing order 10-10-3.
Okay, now,
Yes,
this out of these 3 charges,
yes,
charge number 1 acquitted.
yes,
Acquitted of charge number 1.
yes. Bribery, soliciting.
In the domestic inquiry.
Yes, my lord. The other 2 have been.
In domestic inquiry.
Yes,
And
ma'am. Second is bribery and soliciting, madam.
Charge 2 and 3 proved.
Proved.
Then he went to the labor court.
There was the inquiry report, my lord, is important because these 3 witnesses have been examined.
Okay, where?
That, my lord, is at page 48. 47, it starts.
Yes.
Now, my lord, if your lordships will keep this page 44 in hand, there are 3 people who have been mentioned here in 44 in the charge.
Yes, yes.
So Binod Kumar, my lord has seen Binod Kumar, proprietor, Binod Construction, Rajesh Rai, proprietor, tractor farms and machinery, Jaklabanda. My lord, I'm reading first page 44, my lord, to see who are the 3 witnesses.
Yes, yes.
That is at charge number 2.
Yes.
One is Tractor Farms,
Yes,
Shankar
yes,
Motors, and Binod Kumar.
Yes.
If you compare lordships at page 48, the 3 are there. PW3 is Binod Kumar.
Yes, Vinod Kumar.
PW4 is Rajesh Kumar Rai, who is proprietor of Tractor Farms.
Okay. And
Shankar Motors, my lord. Shankar was also there. Two came, my lord. I think 2 were examined. Binod Kumar and Rajesh Rai.
okay.
Out of the 3, my lord. And the finding is at page, in regards to that, is at page 51, my lord.
Yes.
Issue number 2, whether the delinquent so-and-so dishonestly solicited bribes for repairing work from the garden from the 3 people. And then it says that in order to prove the fact for soliciting bribe in illegal, page 51, my lord.
Yes, yes.
In order to prove the fact of soliciting bribe in illegal gratification, the 2 witnesses were examined by the management. PW3 Binod Kumar Gupta, proprietor of Track Farm Jaklabanda. PW4 Rajesh Rai, Binod Kumar.
So this was proved in a way. This was in the inquiry report.
Yes,
This is the inquiry report.
this is the inquiry report.
Now this was proved. Now what has the learned
Yes,
labor court held with regard to this?
yes. Would your lordship just give me 1 minute to read that, because that part is extremely important, 51, my lord. Both the aforesaid businessmen have got their farms at Amoni and Jaklabanda, and being delinquent employee was authorized to repair machines in good for the said 2 farms. It cannot be argued that the activities of delinquent employee is out of control of the senior manager. Although the places of farms are outside the garden, Yet the senior manager has got jurisdiction to see that no illegality is committed by his employer outside the garden for goods and machineries of the garden. Perusing the evidence of the two witnesses, it is proved beyond doubt that the delinquent officer has taken, soliciting bribe and illegal gratification. Therefore, I swear that before I swear the said issues in favor of the management is against the delinquent. So the entire thing was done based on this based of PWD 5. That is Anup Mehra. That is at page 48, my lord. Who was the manager, then manager. Now, this finding, my lord, has
Page 48, there is, Kumar Gupta and Rajesh Rai.
yes, they are the two witnesses. Correct. Correct. Along with that, my lord, if you see number 5, he's Anup Mehra, senior manager.
Yes.
So he is the what is been referred here as the manager. The senior manager has got jurisdiction to see that no illegality. So he was there at that point of time.
Okay, then.
In this 2 point, my lord, has been taken care by in the award, my lord.
104.
One versus finding, yes, my lord. $104, my lord. They have both been examined, my lord, whatever the two witnesses were, Binod and so and so.
So this is wrong.
Yes, man, that's what I was
This
trying
is
to point
wrong.
out, that these two have been examined.
These two, so this is wrong.
Yes.
PW, who is this MW2?
MW2, my lord, is
Management witness.
it is a Sunil Malik. He's a senior deputy manager.
So he's talking about MW2 and MW5
Yes, the two
Without-
managers.
talking of this Binod Kumar Gupta and this
Yes.
Rajesh Rai.
I tell you why, my lord, because as I read it out, the incident in regards to illegal taking bribery has happened outside the jurisdiction of the tea garden. So that's what the managers have said, that we have come to know that he's taken it. So it's not physically possible for him to go and see where he has taken the money. That is why the labor court says those two people from whom I said that is something which I cannot do. The management can only go and ask the people from whom the allegation has arisen. That they have done. Therefore, within the jurisdiction he has asked.
This Binod Kumar Gupta and Rajesh Rai, they were part of the domestic
Yes,
inquiry.
they were also examined.
They were examined in the domestic.
Yes, my lord, and that's the finding.
So why did the labor court not consider this? There's no reason. Anyway, okay. That's all.
Because the labor court held that the domestic violence itself is not conducted fairly. That's why.
Why? Why not
conduct?
conduct 104?
Because.
It was conducted by the advocate, my lord. That's the ground they have taken.
The
court says that-
was that.
It cannot be a
Finding-
fair
Other
investigation.
applications of Canadian management is.
No, but this is perverse. This finding is perverse because it did not take into account the fact that this Binod Kumar Gupta and Rajesh Rai of the outside firms had been examined, and they have proved the case that he has demanded.
But they were not produced before the tribunal.
They
They were not,
produced before the tribunal, but in the domestic inquiry it has been proved. That's it. Proved.
but domestic, we have challenged, domestic violence is not fair. That is the question. The tribunal is held that domestic.
You see, is it required that the same persons have to be again proved?
The other witnesses.
Ground for challenges.
Other witnesses will be
A
examined.
domestic inquiry is done,
Yes, my lord.
and he's been convicted. I mean, he's been found guilty out of two charges. Now he has challenged that in the labor court.
Right.
In the labor court, is it a fresh round of witnesses have to be produced? Or what?
Not see, they have produced all the witnesses, even senior manager have.
They did not produce these two.
These two, Lord Sir. That's why they have failed to prove this case. And other witnesses, they did not.
No, my question is,
They need to again. Because all the proceedings have started afresh.
The ground for their challenge was the ground that the inquiry was conducted by a person who was not competent to do the inquiry. That was the main ground in which they said. So whether investigated or not, these two people in the labor court, these two people were examined before the inquiry report by the inquiry officer.
No, in the domestic inquiry.
Anyway,
My question is,
yes, my lord.
the persons who were examined in the domestic inquiry,
Right, my lord.
are they required to be again brought at the time the matter is under consideration before the labor court?
My lord, the other,
When they are witnesses in the domestic inquiry, are they again supposed to become witnesses in during the proceedings in the labor court? That is my question.
nobody's. Nobody's on.
Yes, what is the law? You're not answering.
I'll have to check this, my lord. I won't offer it. I'll have to check it.
Okay, we'll take it up again.
Because if until unless this is set aside by any other authority, that may not be required to be done, my lord, until unless this is proved to be bad in law.
Okay, right. On the prayer, the party, this is the matter. On when next Thursday?
Next Thursday, my lord.
Or when do you want?
My lord, can it be on Tuesday if it is not on second, because fourth I'm not available.
Fourth is what? Okay.
Thursday, my lord.
Okay,
Or,
Thursday.
or after
Second.
that, 11th also is okay.
Okay, second.
11th.
11th, my lord.
11. Okay.
11.
11. Huh.
11.
Then you just write the council for the parties submit that the wages of the correspondent has been paid up till June 2025.
Yes, ma'am.
So basically, only that point I want. Then we can dispose it after. Let it come to me. Basically, only one point. That point only I want to know. Because here they were not brought before the labor court, but
Other witnesses.
the other witnesses were brought. So whether the witnesses in the domestic inquiry have to be brought again.
Again. I'll check this, my lord, and I'll get back to you. Extremely good.